Welcome to The Scale of Justice, a program that keeps you abreast of trends in the dispensation of justice in Nigeria and beyond. I am Chukwunonso Nwabueze, standing in for Dele Atumbi. According to legal experts, it is difficult to win a criminal trial with only material evidence without witness testimony. But the challenge prosecutors face in courts is how to get witnesses to court to give evidence. This explains the imperative for the protection of witnesses and the need to support them to build trust and boost their confidence. This is the focus of The Scale of Justice in this episode. Let's take a report at this.
Legal experts observe that it is difficult to win a criminal trial with only material evidence without witness testimony, but the challenge prosecutors face in court is how to get witnesses to court to give evidence. This is because witnesses who should come to court to give evidence in any criminal or political matter are often afraid as a result of threats they are likely to face from the accused or their relations or intimidation from powerful criminal gangs in a society. This explains the imperative for the protection of witnesses and the need to support them in order to build trust and boost their confidence, which Professor Mohammed Tofik Ladan in his presentation anchored on constitutional provisions.
Witnesses play a very important role in the criminal justice system right from the stage of investigation. Investigators need the assistance in order to generate credible evidence and testimony. Prosecutors need their assistance by appearing in a court of law as prosecution witnesses so that they can assist in the prosecution of their actual cases against suspect or accused persons. And then judges in a court of law also need witnesses, to enable them actually give credible testimony so that they can administer justice that is qualitative and also sound. So these are the three stages that a witness or witnesses are needed in any criminal justice system. And like I said, all that witnesses need, of different, classes and of different status, victims, as witnesses, experts as witnesses, participants in a crime as witnesses, collaborators, judicial collaborators as witnesses, people that are compelled by a judge to appear and give testimony as witnesses. Now, all these categories of witnesses need only three things. One, how can they trust the criminal justice system and the operators of the system? Two, how can their confidence be boosted to be able to take a risk, to assist investigators, prosecutors, and even to appear before a court of law and give testimony at that risk against politically exposed persons, and against, criminal gangs in organized criminal activities that sometimes they are even richer and having stronger network than some even governments at national level, especially in terrorism financing, in terrorism cases, in money laundering cases, in drug and human trafficking cases. These are complex organized criminal activities that, the suspects or the accused persons sometimes, they wield greater power both in politics and in bureaucracy, and also in outside even government than some governments, themselves. So these are not the kind of groups that any witness or group of witnesses can withstand. So that's why witnesses need trust of the system. They need confidence to be boosted to be able to take the risk to appear, and they also need the support needed during, after, and before even the trial process.
He advocates programs to be put in place to cater for witness protection and support before criminal trial, during and after trials.
Unfortunately, all the laws that we have in Nigeria today, focus only on protection and support of witnesses during trial, in the course of judicial proceedings. So the question is, when will this protection and support be extended, to witnesses before and post-trial? And will it be extended also to cover civil cases where individuals and corporate entities are also affected? So I think these are the fundamental issues that we have to really underscore. But I think one important point that I actually brought out is the constitutional obligation placed on our government to protect and support witnesses. Section 14, subsection 2 B and C of the Constitution of Nigeria clearly provide for the government obligation to protect all citizens by providing with security and welfare, and which includes witness protection and witness support. So government is not doing witnesses a favor. Rather, witnesses are the ones discharging their constitutional duty under Section 24 of the Constitution of Nigeria, which says that every citizen of Nigeria must provide assistance to law enforcement agencies and must also provide cooperation with legitimate law enforcement agencies. I think that's the bottom line. So neither citizens nor government are doing a favor to each other in a criminal justice system. We are all discharging our obligations constitutionally actually placed, but when it comes to government, they also have treaty obligations to observe, respect, comply with, and then enforce.
The training is attended by personnel from the EFCC, ICPC, NAPTIP, Immigration, the Police, Army, INEC, and NIA.
We speak with some stakeholders in the administration of criminal justice on the subject matter. For more insight on the subject matter, we have Eko Ejembi Eko, Senior Advocate of Nigeria. We'll begin by asking you, what is the place of a witness in a criminal trial proceeding?
The witness is the gravamen upon which the facts as alleged are usually provable or proved. It is the testimony, the evidence that the witness provides that makes the difference between whether you have a conviction or an acquittal. In a criminal trial, even in a civil trial, it makes the difference between getting judgment in your favor or losing the matter. Evidence on its own does not just take itself and walk to court. The witness brings it either by direct eyewitness account or by viva voce testimony, or even documentary evidence or real evidence. However you cut it, for purposes of trial advocacy, the role of a witness cannot be understated. Even in arbitration, you can't get very far without witnesses.
There are situations where a witness or witnesses gave evidence in court and such individuals testified against unleashed terror on them. What kind of protection and support are available to these kind of witnesses?
Well, it still is a lot to be desired. Factually speaking, how are we protecting our whistleblowers? These are the people who we are hoping to turn to witnesses to support our allegations of corruption, to support allegations of even treason. We should do better to protect witnesses, but we're not doing enough. A man comes to testify in support of an offense done to the state. How does the state protect him? How does it stop him from this very big man or very influential figure or very terrible crime lord coming after him after the trial is over? If he survives the trial. Even if he doesn't survive the trial, what stops his cronies and allies from coming after him? That is where the role of witness protection comes in. It's a self-evincing thing. This person needs assurances of his own welfare to be able to tell you the truth that otherwise you could not have gotten. And it encourages others to see a wrong thing and come forward because they know they will not be victimized, because they know the state to protect them from victimization or being picked upon. But without that safeguards in place, you leave them to their own fate.
I believe the essence of the act is to take care of the anomalies to ensure that this works. How do we learn from other crimes to ensure that this act is fully implemented in Nigeria?
You can have all the beautiful laws you want, but without actual implementation and the facilities on ground, it's just wishing on a dying star, if I may be so bold. Before now, the role of witnesses and their welfare is covered in most of the rules of courts. But how well is the letter of the law being followed? How well is the welfare of the witnesses being catered for? How well are the witnesses being protected? We heard of the famous whistleblower, I think in the Koi issue. Have you asked yourself whatever became of him? Did the matter eventually get to trial? And if not, why not? You see, some of these things are instances of our failure. You create a Whistleblowers Act to encourage people to report ills in the society without putting practical measures in place to protect them. It discourages truth-telling from an anonymous source. And it also discourages the anonymous author of information from coming out to say so. Without the protection in place for them, it will be suicidal to participate otherwise.
What happens if a witness who made a deposition in a criminal trial fails to appear in court to give evidence and to be cross-examined?
Every deposition goes to no issue. It's like pleadings. Pleadings that are not supported by any evidence. What does it go to? It goes to no issue. The man deposed to it, then he has not come to adopt it before the court. How do you know if he is not going to resign from them? How are you even sure that was his deposition? Some of these factual practicalities only come into play in practice. You have a piece of paper that you allege that Mr. A deposed to on a particular day before a particular commissioner of vote. Mr. A is not there to say otherwise. What if the other side alleges that it's forged or it never happened? In the state of our practice presently, it becomes a very, very hard ask to continue based on the position without the deponent coming to give evidence. It's abandoned testimony, if you ask me.
Do you subscribe to a pool of funds being made available to cater for witnesses who might have difficulty coming to the court to give evidence as captured in the act?
If it is going to be used properly and if it is going to be implemented correctly, I'll stand and applaud it. But there are so many lacunas in implementation that you begin to wonder, who is warehousing these funds? How do you get to know the need of the witness? How is he brought to court? How is he taken back? Look, the letters of the law are beautiful, but it's the spirit behind it that we are speaking to now. The law exists to cure a mischief, but is this mischief actually being spoken to practically? That is the question. It's not so much about having policies and laws in place. We must bring in a structure that will make those laws work for us. A structure must be put in place to make these things, take it away from the paper and bring it to the streets. That is what we should be looking at. Yes, I applaud the lawmakers. Yes, I applaud the executive. But then again, we need more if we are to move forward. In the rules of most courts, there is provision for welfare of witnesses to come to court. It's the practicality we are speaking. We can make 150 laws, but without the spirit to implement it, without the facilities and the structure on ground, without the actual will to so act, those laws are just academic. We need to look ourselves in the mirror and ask ourselves the germane question. What is the problem? Do we have a problem? How do we better the situation? Why are witnesses not coming forth? What can we do to protect these witnesses? Practically, not legislatively. So once we have come to that realization, once we agree on what to do, then the next step is how do we go about doing it?
Synergy between critical stakeholders in the justice sector, the courts, the law enforcement agencies cannot be overemphasized in ensuring the protection of witnesses. What's your take on this and how do we get it right?
Without them, it will never work. That's just the blunt truth. Most of these witnesses interact with them. They know the witnesses. They know the needs of the witnesses. They know where the witnesses are coming from. They interact at the most basic level with the witnesses. So if you don't take their views as stakeholders into play, then they are still running around in circles. For purposes of criminal justice sector, the lawmakers can make all the laws they want, but without the security enforcement agencies, it will not really work in implementation. That is just the hard truth. The people that go after these criminals, the people that have informants, the people that investigate, the people that do the hard work, they must be called in to have a sit down as to how best to implement this. In other crimes, there's a system in place. There are witness protection programs in other crimes. Let's just look to them. What we are facing now, the US faced it a long time ago when they were fighting the mafia. They established a very efficient witness protection agency and program and worked. They still do that in fighting drugs and narcotics, so to speak. Look to what is obtainable, what has been progressive, what actually works in other crimes, bring it home. Simple.
Thank you, Eko HMB Eko, Senior Advocate of Nigeria, for coming on Scale of Justice.
You're welcome.
In what appears to be a cheering news to conflict mediators, the Court of Appeal has ordered the unfreezing of the former Chief Justice of Nigeria, Justice Samuel Walter Onogen's bank accounts in Standard Chartered Bank, Wuse, Abuja. This was after the court discharged and acquitted Onogen from the charges preferred against him in 2019 for not properly declaring his assets, leading to his removal from office and the freezing of his bank accounts. The consent judgment is the outcome of settlement terms reached by counsel to the federal government and the former CJN.
Let it be known by the whole world that judiciary in Nigeria is one of the best in the world. We have men and women of character learning who have sacrificed their life from their early age to old age to become anything in judiciary. And yet people talk flippantly, they talk recklessly concerning these eminent Nigerians. If we don't respect our judiciary in Nigeria, the whole world will not respect judiciary in Nigeria.
One case that is being followed up by Nigerians is the police versus Alex Ikweche, a member of the House of Representatives representing Aba North and South Federal Constituency, who was charged to magistrate court for assault to a boat driver in his house. At the resumed hearing of the case, counsel to the defendant, Odi Ajike, sought the leave of the court to move a motion on notice, which he said had been served on the prosecution. In his objection, the prosecution counsel, Ibrahim Mohammed, said although his attention was drawn to a service copy of the alleged motion in the court file, he was yet to be duly served. He therefore prayed the court for time to be served properly to enable him respond to the said motion adequately. Without any objection from the defense counsel, Senior Magistrate Abubakar Umar adjourned the case to 22nd of November 2024 for the defense counsel to move the motion. He, however, reminded counsels that there will be no room for longer adjournments in the matter in order to meet up with the 180 days adjudication period in criminal matters as provided for in the Administration of Criminal Justice Act 2015. Alex Ikweche is standing trial over allegations of assault and threat to life of an Uber driver preferred against him by the Inspector General of Police on behalf of the federal government. The defendant, who was in court for the day's proceedings, had earlier pleaded not guilty to the charges. Issues contained in the motion sought to be moved by the defense counsel were not made known. As part of the continuous reforms in the justice sector, the Chief Justice of Nigeria, Justice Kudrat Kekereekun, has urged judicial officers to reject actions that could tarnish the image of the judiciary or impede fair administration of justice. He gave the charge in Abuja at the induction course for newly appointed judicial officers of the Superior Courts of Record. Converged here at the National Judicial Institute, Abuja, for the Stream 2 of the Institute's 2024 induction course for judicial officers of superior courts in the country are the newly appointed judges of the Federal and State High Courts, National Industrial Court, caddies of the Sharia Courts of Appeal, and judges of the Customary Courts of Appeal.
The judiciary serves as the backbone of democracy.
The Chief Justice of Nigeria, Justice Kudrat Kekereekun, while warning judicial officers regarding the indiscriminate granting of ex parte orders, charged the participants to execute their duties with unwavering integrity and dedication in order to reinforce public confidence in the nation's justice system.
The congestion of our correctional facilities. A factor contributing to this problem is the excessive issuance of remand orders by some judicial officers. We must make every effort to change this narrative. Heads of court, in collaboration with attorneys general of respective states, should routinely visit these facilities to assess conditions firsthand and develop effective strategies for decongestion. One viable approach is the adoption of non-custodial measures and restorative justice, which can yield outcomes of reformation and rehabilitation, but that might not be achieved with custodial sentences. Judicial discretion in the issuance of remand orders must be exercised with careful consideration of the particular circumstances of the case. We must remain conscious of our control over our courts and uphold this responsibility with firmness and prudence. My lords, I must emphasize that the judiciary is an indispensable pillar of governance, and its true independence is essential. This independence, however, can only be maintained when our constitutional functions are free from external interference by other arms of government. I urge each of you to be courageous and honest in your judgments, ensuring that you are impartial and not swayed by external factors of any kind.
The selected theme, the positioning the course for better justice delivery, alongside the content of the course, was specifically chosen to stir up a consciousness of the sensitive position which you now occupy and the attendant demands and the expectations that come with it, and to ultimately invoke in you a sense of responsibility as agent makers of the judiciary. While we have made slight adjustment in order to enhance the learning experience and outcomes, I wish to assure you that in order to maintain consistency and coherence in the knowledge and information sharing, we have ensured that the content of the course is fundamentally the same with the Abuja justice received during the first stream of the induction course, organized from the 6th to 10th May 2024. Additionally, you will agree with me that the correlation between judicial efficiency and capacity building is one that cannot be overemphasized. Hence, following this all-important induction course, we look forward to receiving and recording the participation of your lordship at various training programs tailored to build your capacity in various areas of law and to equally enhance your functionality.
With the theme, Repositioning the Course for Better Justice Delivery, the induction course is specially designed to indoctrinate His Lordships in the peculiarities of the higher bench, as well as to familiarize them with the art and craft of justice delivery pertaining to their new roles. This is where we draw the curtain on the program. Thanks for watching. Till we come your way with another package, I am Chukunonso Nwabueze.